Hello, everybody. Thank you so much for joining us today for our webinar. We try to host these once a month. So if you know anybody that this might be useful for after you're done, please feel free to share this with them. There's no obligation. Anyone who does attend this webinar is entitled to a free personal consultation with one of our attorneys over the next 2 weeks. So if what you hear applies to you or you hear something that you would like to further discuss with an attorney, we will be posting a link throughout this webinar. So if you go to the bottom of your screen, there's a Q&A button. We'll be having an attorney monitoring this live, and they will be posting a link throughout where you can schedule a consultation from the comfort of your own home. Otherwise, we should be calling you within the next couple days to schedule an appointment. If you prefer not to schedule online, I totally get it. My name is Blaire McClanahan. Again, I'm one of the attorneys here at the law offices of Cheryl David. Among a few other attorneys, there's Justin Plummer, Gia Gaster, and Cheryl David. We all handle estate planning. So for those of you who do opt for a free personal consultation, you'll be seeing any one of the three of us. It's typically scheduled blind. So depending on the day and time that work for you for that consultation, you'll have an attorney selected. Now, if you have a specific need to meet with an attorney to discuss nursing home asset preservation or probate administration or death administration when someone's passed away, do please put that in the notes so that we can make sure that you're with the right attorney. Tonight's webinar should last a little under an hour, I'm hoping. Bear with me. I love to give information out, so sometimes I get away with the time, but I am going to try to keep it under an hour. Again, anyone attending tonight's webinar gets a free personal consultation as long as you schedule with the attorney over the next 2 weeks. Typically, we have a $425 consult fee. So if you were to call in off the street, having not watched this webinar, that consult fee would apply. So if you do want that waived, we do suggest scheduling that within the next couple weeks. If you have any questions, technology issues, there is, again, this live chat that's being monitored. Do keep in mind who can see that chat, so we don't want too many private details unless you want to select only the admin to see that. All right, I'm going to go ahead and share my screen. Let me know again if you have any technology difficulties. Hopefully not. All right, here we go. So I am going to start this meeting with a video from our office.
I got a dreaded phone call. My sister was in intensive care. We made it up there and she passed away. She had contracted bacterial meningitis. And the thought that I could lose somebody so dear to me so quickly was devastating, and it made me rethink absolutely everything, but especially my career. Realizing that what we went through with my sister was something that happened to people every single day. And I thought if I could be of help when people are going through that horrible time in their life and make it a little bit easier.
My husband, Wiley Harris, passed away in 2017. And then I realized I needed some help. The human aspect means a lot to me. And some places are business, business, business to the end of day. But they have been very conscientious and they have led me into the right direction. She got some great people working with her. I just have full faith and confidence in the staff.
It's very special to me that we help families, but we're also a firm that's comprised of a family. It's myself, it's my daughter Blaire, the other attorney that I work with, Justin Plummer. He's like family. The clients respond to this family atmosphere, and I think that they can feel that we really care.
Well, I wanted to ensure that my family would be taken care of.
We
Also first met Cheryl through his mother, who came basically to live with us after his father passed away, and so we would try to make it simpler when it came time for us to deal with her.
After we met Cheryl, she gave us the ropes, and transfer of the estate took a matter of weeks.
No one wants to talk about death, but it's something that's inevitable for each and every one of us. It's smart to come in and have a conversation, because if you don't have a conversation, you're not protecting those that come after you. We recommend that you come see us at the law offices of Cheryl David, and we'll sit down and we'll listen to you, and we'll try to come up with the best plan that we possibly can.
Thank you so much for watching. I know we have some people that just logged on. My name is Blaire McClanahan, if you missed that, and I'm one of the attorneys here. So we have some ground rules for today's webinar. First, please jot down any comments that you have in the chat feature, ask questions in the Q&A icon, and we're going to be scheduling a link throughout with a meeting schedule calendar. You can schedule any meeting you'd like with the attorney, as long as it's to discuss your estate planning over the next couple weeks. Those are blind meetings, so they'll be with one of the attorneys at our office. And if you prefer not to schedule, we'll give you a call over the next couple days. So tonight we're going to talk about estate planning, elder law. We're going to go into a little bit about what probate looks like. But to start, I'd like to discuss the reasons that we find that people don't plan, among others. So the first is procrastination. There's always tomorrow. This isn't the most fun conversation to talk about. So people just put this off, put this off, put this off. But I can't tell you how many times we have been making last minute hospital visits. Someone's in hospice because putting it off, the time to act just never came. And those are not the best times for you nor for your family to really be making plans. And sometimes the unexpected occurs. We have certainly seen that over the last year or so. So we want to make sure that we give you the tools so that you can make a decision and get started sooner than later, so that we're not having to make these last minute decisions when sometimes it's too late. So while you're competent, while you're able to make these decisions, while there's not an emergency, we really find that this is the best time to discover, explore your estate plan. Another reason people don't plan: lack of knowledge. There's continuous changes in the law, and today's traditional estate planning may not cover tomorrow's issues. So we want to make sure that we give you that knowledge tonight. And I will be the first to admit, we never know what's going to happen with the law. However, we don't, again, want to procrastinate to the point that it's too late. And finally, there's a lot of complex legal issues, and it gets so cumbersome that we find that sometimes people are just totally turned off from doing this altogether. There's different terms like probate law, civil law, tax law, real estate, Medicaid. Oh my goodness, so many words. Today, we're really going to focus on estate planning. So what is the most valuable to you? What do you want to protect? So for some of us, it's our spouse or our family. Maybe we have children or great-grandchildren. For a lot of us, it's our health. We want to make sure that we don't outlive or outlast our money. Our friends, our charities, our business interests, and for me, a very important one, our pets. So I'd like to give you a case example. This is Bill and Mary Jones. They're a North Carolina couple, 65 years old, with an estate worth about $700,000. They have 2 kids. Susan, an accountant, she calls every day. She lives down the street. She brings her grandkids by to visit at least once a week. She's a smart lady. Unfortunately, she is married to this guy, Jason, who we'll talk about it more in a minute. And then there's John. What can we say about John? He lives in the basement. He's really never been able to hold down a job. He didn't continue the education that Bill and Mary wanted to see with him. If you give John $1, it will be gone almost before it reaches his hands. So John is definitely one that we want to watch out for when it comes to how we intend for him to inherit money. So Bill and Mary have several planning options, as do you watching this webinar tonight. Option one, spend every last dollar. You may have seen the sticker on the cars that I'm driving my child's inheritance. You know, this is an okay option if you can really plan to the very last dollar. But what we find often is we don't want to outlive our money and we can't plan when we're going to pass away. So spending our every last dollar is not always the best option. And usually, even if it's not a lot, there's something left over. And now our families have to go through a court process called probate to get that amount, even if it's not a lot. Another option is die intestate. So for people that don't have a will, this is North Carolina's plan for you. And it may not be the plan that you would pick for yourself. If you're married with kids and you don't have a will, you may be surprised to hear that everything does not automatically flow to your spouse. So at a minimum, for a lot of our married clients where that's not what they want, we need to have a will in place that says everything goes to my spouse at my death. And then when both of us are gone, it goes to our kids. If you are married but don't have kids, but have in-laws, you may be shocked to find out that, again, not everything goes to your spouse. It is split with your in-laws if your spouse passes away. So this is risky. And there's a very easy solution to this. Have a will. We can be very intentional with who we want to give money to and the terms that we want to give it to them with. Another option is put everything in joint tenancy. So this, you may have a bank account with a child or a spouse on it. That's joint tenancy. And if you've selected to have rights of survivorship, everything goes to that person at your death. So a lot of times our husband and wives have all of their accounts in joint tenancy, and it will not go through probate. That money will not go through probate when they pass away. The issue is eventually there will come a day where both people are gone. And now we are back to intestacy, or if we have a will, we can at least direct where things go that way. But joint tenancy is not the best solution. For parents that often come to me and say, well, what if I just put my child's name on that account? I do want you to know that if we do that, that account becomes your child's, half of it. And their problems now become your problems. If they get a divorce, if they are sued, this money is totally accessible. So there are better ways that we're going to talk about tonight. Joint tenancy works nice for a spouse, but we really need to think beyond that. A lot of our clients create a simple will. I'd say half of our clients opt for wills. So I'm not here tonight to tell you that a will is a bad option. It is a great way to be very intentional with who we want to leave money to and our directions for our loved ones when we're gone. There's also something called a bare bones trust or an unfunded trust. And I would argue that 98% of the trusts that come across my desk on a day-to-day basis are these bare bones trusts. It's beautifully written. It probably says exactly what you want it to say, or if not, we'll help you make sure it does. But these trusts don't have anything in it, okay? And with these trusts, you still end up putting your family through a full probate administration when you pass away. And oftentimes you're none the wiser. You relied on the attorney to create this trust. You probably spent a lot of money on it under the understanding that you would not go through court. So what gives? So with an unfunded trust, they all go through probate. Hear me again. Unfunded trusts are going to go through probate. I want you to think of your trust like a piggy bank. And a trust, before I go any further, it's just like a will, but in contract form. And when it's done correctly and your assets are tied to this trust, nothing goes through probate. So at our office, that's very important. But what we find with these 98% of trusts that come across our office is they don't have everything inside of them. So again, the trust is a lot like a contract, a will in contract form. And just like you may have contracts with your painters, handyman that don't go through court, neither does this one. Unfortunately, the reason that we see a lot of these trusts not work, again, nothing is in them. So what do I mean by that? So I mentioned earlier piggy bank. I want you to imagine your estate is a piggy bank or your trust is a piggy bank. Everything needs to be inside the piggy bank for you to really be shielded from probate court when you pass away. So how do we do that? We contact the financial institutions, like your bank, for example. And instead of that account being in the name Bill and Mary Jones, it would be in the Jones Living Trust. Your house would be in the Jones Living Trust. But unfortunately, we see too many attorneys create a trust, but they don't put anything in it. And I have various reasons why that might be. One, it takes a lot of work to fund a trust. At our office, we have an entire meeting dedicated to going through assets with you and making sure that everything is titled the way that we need it to be. And for a lot of attorneys, they just don't have the infrastructure to do that. We have an entire team, two people that really, most of their day is spent reaching out to financial institutions, filling out forms. Another reason, attorneys make a lot of money when they get to handle your probate. Attorneys get to charge 2 to 5% of the estate when they are managing the probate. So just think of those numbers. Attorneys stand to make a lot when your estate goes through probate. The final option, my favorite, is let's create a complete estate plan with a revocable living trust, but one that is funded, one where your house and your bank accounts and investments are titled or linked to that trust, a power of attorney, and your health directives. So one thing I do want to mention, I've mentioned advanced directives, healthcare powers of attorney, financial powers of attorney. These are very important in order to keep our family from going through the nightmare of guardianship. So a financial power of attorney and a healthcare power of attorney are documents where we can list someone that we trust to handle our affairs if we are not able to one day. Unfortunately, all too often we see people procrastinate and they don't get these documents in time. And now there's been a stroke or some incapacitating event where they are no longer able to handle their finances. They are no longer able to make competent decisions regarding their health. And unfortunately, without that, our spouse, our kids are not automatically able to make our health decisions or our financial decisions for us. So we end up in a predicament called guardianship. It is humiliating. The court is totally in charge. We have to get their permission to do everything. It's time consuming. It's not just, it's going to take a few weeks to file this thing and get appointed. Every year we are having to file accountings with the court showing where every penny went. Personal information is disclosed. So the Freedom of Information Act makes these public, and it's expensive. The court takes fees to set it up. They take fees annually. Attorneys take a fee. Guardians take a fee. So what I'm getting at is this is expensive, and it is totally avoidable if we have a power of attorney for our finances and one for healthcare. And while some states might combine those, North Carolina has those as two separate documents, and each person needs their own. So even if you're married, we can't combine those. And the reason I mentioned North Carolina specifically, all states have different laws, okay? So a power of attorney that you have in another state or a will in another state may not suffice for North Carolina. So we want to make sure that if you have a plan, it works with the state that you're living in. Okay, so one time that we find people going through court a lot is guardianship, as I've mentioned, and another is the death of a spouse. So when, or your death, your family will have to go through court when you pass away if things aren't set up in a way that we can avoid that. So I want to go over that process, that probate process. And probate is the name of administering the will in the courthouse. It's called probate. And do you have to go through a probate if you have a will? Absolutely. A will is a ticket to court, okay? So in North Carolina, a will is a great option for directing who do we want the court to appoint, how do we want the assets to be distributed, but it does have to be filed with the courthouse to be activated, okay? So again, it is a ticket to court. So that process is designed to give notice to all of interested parties. Sometimes we have to track down heirs. I have a case right now where someone died, they didn't have kids or cousins, not first cousins, and we're having to use an heir search to track down these relatives. And that may not apply to you, but maybe it will to someone on here. It's a forum to resolve disputes, and all parties really have a say. We pay the creditors. There's an inventory process. A lot of people have to be bonded in order to become the executor or administrator. And oftentimes we find that these probates last at least a year. And the reason for that is tax clearance. So especially for people who pass away early in the year, like January, maybe they had enough income accrue during the time that they were alive where they're going to have a filing for that year. So let's say someone died January 2025. We're going to have to keep this estate open until we can at least do the tax filing, which will not become live until sometime early in 2026. So it is very common that these estates last a year. Even for people that die, July, August, September, these estates still often take a year. They're just not a quick process, and these clerks have hundreds, if not thousands, of cases on their desk. And finally, when this year process is over, we distribute out the estate. And that is really the probate process in a nutshell. It is a public process. So again, like guardianship, freedom of information law requires that this be public. So any of you could drop down to the courthouse tomorrow and check out anyone's will that's been filed and see exactly what's been going on. So why should we avoid probate? Among many of the reasons that I just listed, it's expensive. So I've already told you attorneys charge around 2 to 5% to manage a probate, but your executor or administrator also gets 2 to 5%. And the court's going to get a fee. They get paid $4 on every 1,000. There's fees to publish the notice to creditor in the newspaper. There's a $120 fee to file at the courthouse just to open the estate. You get it. We end up seeing people lose 5 to 10% of their estate going through that process. It's time consuming. So I mentioned that year. And it's public, and there's probably going to be multiple probates if you have real estate in various states. So that is including timeshares. We have a lot of clients with a timeshare, maybe in South Carolina or Florida, or maybe there's a piece of inherited land in Virginia. There's going to be a probate in every state that you have real estate. And there is a way to avoid this, because I know this sounds like a nightmare for some of you, and that is really a trust. So what about death taxes? So the good news for most of you, there's not any death taxes that we need to worry about. We only have estate taxes on estates over 13.99 million. And that is set to sunset at the end of the year, possibly down to 5 million. With indexed inflation, that might be 7. Honestly, I have questions if that's even going to last. It may not. Another good piece of news for you, there is no North Carolina inheritance tax. So if you pass away in North Carolina and have an estate under 13.99 million, there's really not going to be death taxes that we have to worry about. And if you do have one of these larger estates, we get to double that exclusion. So you wouldn't have to worry about taxes until you're almost at $28 million. Okay, so this is expensive. So Bill and Mary's estate grew to around 1.4 million by the time they passed away. Probate ended up being very expensive. 5% would have been around $49,000 if they passed away without a trust. Let's say while they were living, they became incapacitated and couldn't manage their finances or health decisions anymore. We're probably looking at about $7,500 each just for the attorney's fees to handle a guardianship, something that could be absolutely avoided with a power of attorney. And I do want to discuss a little bit about nursing home costs as well. We have an attorney at our office, Gia, who focuses solely on nursing home protection for families and often is able to protect anywhere from 50% to everything for someone who has to go to skilled care. If you are married and your spouse is still healthy, or you're still healthy and your spouse goes to the facility, usually we're able to protect almost everything, even if we don't have 5 years to move money around. Okay. Now, for people who are single, usually we can protect up to half of the cash. And this is if we don't have 5 years planning. For people where we have 5 years notice, which for most of us we don't, we can protect everything if we have 5 years notice. But again, a lot of people don't have that much notice. So I'm not going to go through all these numbers, but you can see we have lost just an incredible amount of money having to go through probate, going to nursing homes. We typically see that's anywhere from 12 to or 10 to $15,000 a month. So people lose just a ton of money going through that process. If you have a loved one going to a nursing home, please contact us. There is so much that we can do to protect money. There's a very special power of attorney that you need to have. Not all powers of attorney have this language that lets Gia protect your money. Okay. So for those of you that say, oh, you know what? I just have a power of attorney done last year, I'm good. Not all powers of attorney are going to allow us to protect your money. There was a law change with powers of attorney in 2018, but even some of the new ones don't have that language. So if you're not sure but want us to check, we're happy to review that. So if you do not act and give a voice to your own wishes for your North Carolina estate plan, North Carolina has a plan for you, and it may not be one that you want. Money may not get to who you want and when you want, or be handled by the person that you'd want. So we want to have a plan in place to protect against these things that we've discussed: guardianship, probate, estate taxes, court battles, okay? Long-term care costs. There's a lot that we can do if we have notice, and if we have these documents like powers of attorney in place before you pass away. So we've talked a little bit about wills. A will is being a ticket to court. We list who we want in charge, but I want to spend a moment talking about revocable trusts and how they work. So I mentioned earlier, a trust is like a will in contract form. It is a will that does not go through court. So if Bill and Mary have a trust and they put their house in the trust and their bank accounts in there, and it lists Susan as being in charge if something happens to the both of them, we have a tool for avoiding probate. Okay. So I mentioned earlier, everything for this trust to really work needs to be titled in the name of the trust. Their joint property. Maybe Bill has property. He has a little stock account that he likes to play with. That needs to go to the trust. Mary has a checking account with an inheritance. That needs to go to the trust. So everything needs to be titled in the Bill and Mary Revocable Living Trust, or the Jones Living Trust. You'll get to pick out the name. And again, this is the step that we find a lot of people miss. And how do you know if you have a trust that nothing's in it or everything's in it? My suggestion would be the next time you go to the mailbox and pick up your bank statements, check and see whose name that's written out to. If it is in Bill and Mary Jones, it is probably not in the trust. You should be seeing the word trust or trustee on there to know whether you have a trust that has funding. Okay. And we mentioned earlier, there's lots of reasons that attorneys don't fund: the time commitment, that maybe they hope that they'll get the probate when you pass away. But please, please protect your family and make sure, if you're going to go through the expense of having a trust, that everything is titled into the name of that trust. Now, there's certain assets that you don't change the title of: IRAs, 401ks, those are in your name. But I do like to name the trust as a beneficiary after your spouse. And the reason for that is sometimes our kids are not in a position where they should be inheriting money outright. Okay. I mentioned earlier their daughter, Susan, who may be going through a divorce. And if we were to name Susan as a beneficiary of an insurance policy, of an IRA, and she inherits that money and then throws it in her account with her husband, we now exposed this money that you worked so hard for to our child's marriage. Or John. We never want to name John as a beneficiary. That money's going to be lost. There are lots of people out there hoping to relieve him of his money. So there's different ways that we can title assets to protect it. So John most likely needs something called an asset protection trust. The money placed in his trust is there for him, his needs, but he probably should not be the one controlling it. And for Susan, we are going to do something called an access trust. She has full access to that money, but it has divorce protection. So why create a living trust? There's a lot of reasons, but mainly to avoid probate when you pass away. And while you're alive, it's really business as usual. This is more so a standby device to keep your family out of probate when you pass away. So you're really not going to see a whole lot of change while you're alive. Everything is still under your control with a revocable trust. And yes, there are trusts out there. There's something called an irrevocable trust where you don't have as much control of your money. That's really not what we're focusing on today. This is a trust where you have full access. It follows your social security number. There's no special EIN or state ID numbers. There's no change with how you pay taxes. We are really using this as a way to keep your family out of court. A trust never dies. It's a living trust. And it does not have to go through probate. So we get protection from guardianships, even from probates when you pass away. We can avoid going through court. So I mentioned this is like a will and contract form that does not go through court. And I really want to make that point. We do not have to go through probate if you have a trust and everything is titled the way that it needs to be. And we can protect our spouse and our children and our grandchildren and our pets. So with a trust, so in this instance, let's imagine Bill and Mary had a full trust. They had a power of attorney, the special one with the nursing home protection permissions that I mentioned. They have healthcare powers of attorney. We have a means to avoid guardianship. And even our clients that do will packages, that includes a power of attorney and healthcare power of attorney, we can avoid going through this guardianship. So everything I talked about earlier, the expense, the public humiliation, loss of control, those fees, it's something that's very avoidable. I spent the first few years of my career handling guardianships, and there's a great reason that I don't do it anymore. Thankfully, Gia at our office does handle those, and she's often in court monthly, helping people who just did not have their plan in place on time. Now, with a trust, Bill and Mary don't need to worry about probate. Everything was titled in the Jones Living Trust. So we've avoided having to go through court. We've avoided the fees, that 5 to 10% that executors and attorneys get paid, that year plus that people go through court. We don't have to deal with that. No notice to creditor in the newspaper. We don't have to worry about keeping this thing open because we needed tax clearance, which we don't get for some people for a year. If you have a trust, that is what we need to file your tax return. And if you have multiple pieces of real estate or a timeshare, we avoid having to have probates in multiple states. So all your real estate will be titled in the Jones Living Trust. And while we are North Carolina based and only can handle your North Carolina deeds, although we do have Justin who practices in Virginia, we have an amazing network of attorneys throughout the country, even some in Hawaii, where we can lean on them to handle deeds for us if need be. So I want you to think of a trust like a tube of toothpaste, okay? And if assets are in the tube, which is the trust, they are protected. Whereas not having a will or even a will sometimes, or having joint tenants on your bank account, outright distributions are like putting that toothpaste tube on the ground and stepping on it, and the product goes everywhere. And it's full of bacteria now. We can never get it back in the tube like it used to be. It's exposed. And therefore it's exposed to all of our loved ones' problems. So if you leave assets to your spouse and then they get sick, or you leave it to your kids, but there's a divorce, or we have a child like John, everything is exposed to their problems. I'm going to hit on special needs trust a little bit as well. So if you have children or grandchildren or spouses with special needs, There is a lot of delicate work that needs to be done so that your family members do not lose their benefits. So oftentimes we find people on Medicaid, and we want to make sure that they don't inherit money to where they are kicked off of their benefits. So our office spends a lot of time working with families to protect assets from loved ones that have special needs. So please let us know if this applies to you. We do this a ton, and we need to protect our loved ones. So with the revocable trust, we have protection for every issue that Bill and Mary has faced. So neither of them is going to go through a guardianship. And because they had a trust and all of their assets were titled in the trust, when Bill passed away, everything flowed to Mary. And then when Mary passed away shortly thereafter, everything flowed into the trust for her kids. Susan inherited her money in an access trust. And this is all these different types of trusts, the asset protection trust, the access trust. These are just, it's all special language that we put within your trust. So we can shield the money from Susan's divorce, John's lawsuit. We have protection. And unfortunately, when our kids inherit money outright of trust, uh, it is very exposed. And especially if you have minor kids, I do want to hit on this for a second, or minor grandchildren. We never, ever want to name them as the beneficiary on life insurance, on IRAs, on 401ks. I have a son, 3 years old, Benny, and a lot of my friends, I've noticed with kids the same age, they've named their kids as their beneficiaries on their policies. So maybe this doesn't apply to you, but maybe it does to your children or grandchildren. Never name a minor as a beneficiary, because what ends up happening is the court takes hold of that money until they're 18. Okay. And if we need to use that money for school, for a car, for health, we actually have to go through an entire public court process to get access to that money. Guardian ad litems have to be appointed. We have to get permission to spend. This is even if you have a will, because money left to a child as a beneficiary doesn't go through the will. So there is a special way that we can protect money for minors. Um, and I'd be happy to talk with you about that. But again, if you take nothing else from today, please don't ever name a minor as a beneficiary outright. We need to leave money for them in a minor's trust. And we can do that in your will, or we can do that in a trust even. But we need to make sure that we're not just naming them outright. Okay. So a lot of protection that we're getting from the revocable trust. But one of the biggest protections that our clients love is immediate access to assets. So as soon as death certificates have been received, which typically takes 10 days after someone passes away, we should be able to go ahead and have your trustee take over your accounts and start using money. We've hit on long-term care planning a bit. What happens if you get disabled and need long-term care? So we have an attorney at our office, Gia, who handles a lot of our asset protection for people that need skilled care. I mentioned earlier, if you're married and one of you is healthy, we can usually protect almost everything except for maybe the sick person's income. But sometimes even some of that we can protect. But we have to have the world's best power of attorney to do it, okay? Not all powers of attorney have that language, and that's intentional. The government loses a lot of money when you protect your money. But as far as I'm concerned, these Medicaid benefits are a program that you've paid into your whole life when you've paid your taxes. And this is a program that you deserve to have work for you as well. Okay. And I'm not okay seeing someone go to a nursing home spending $12,000 a month and impoverishing their spouse at home. I'm not okay seeing that you've worked your whole life to lose your money because maybe you had a bad deck of hands and got Alzheimer's or had a stroke. And now money that we had been saving for our children has gone to some nursing home. I'm not okay with it. Okay. So if this applies to you, please come and speak with us. There are so many different things that we can do. For some clients that don't have planning in place, they're going to use their own money to pay for long-term care expenses. Not on our watch. Okay. Some of our clients have a long-term care insurance policy. Those are amazing options, okay? And if you need to talk to an financial advisor to discuss whether you might be a good candidate for long-term insurance, we have someone you can talk to. And if you have those policies already, I know they're expensive, but they are worth every cent. Personal story here. My grandparents, and they've given us permission to share this while they were still healthy, both now have dementia, and they're about to go into a nursing home, and it is going to cost over $30,000 a month because they are both very, very ill. But they had long-term care insurance, and every cent of this is now covered. And I know that's not the story for most people. So if that's the case, please call us, because even if you don't have long-term care insurance, there's a lot that we can do to protect assets. If you're a veteran and meet the certain criteria, like having served at least 90 days in one of the major branches, and at least one of those days was in wartime period, and you meet the asset and income requirements, you may be entitled for a benefit called aid in attendance. And a lot of people don't know this exists. It entitles a widow a little over $1,100 a month, or the veteran over $2,100 a month. If you have someone who helps you with your VA benefits, please ask them if you are eligible, because there are millions of people in this country that are and just don't know it. Medicare is an option. I have a family friend that just contacted me this morning, and her loved one is going to be going into a Medicare bed at a rehab facility. And Medicare is going to cover for about up to 21 days. And sometimes it lasts longer with a copay, up to 100 days. And sometimes I've seen it shut off at 10 days when the doctors determine you're not getting better. But Medicare does not last forever. So I want to make sure that everyone here knows that and has another plan that's not Medicare. And Medicaid is really the benefit that our office can work some magic with. We could get people on Medicaid benefits. And I know Medicaid has this connotation, it's only for broke people, but that's not necessarily true, okay? We can artificially impoverish you or move money around in using special annuities, or there's a spousal allowance that we can use. But there are so many ways, even for people that have hundreds of thousands of dollars, even someone with $1 million, where we can access these benefits for you to protect your spouse so that they're not broke, to leave money to your kids, to not give every dime to a nursing home. There's so much that we can do. Okay, so there's myths with Medicaid. One, that you have to give everything away or spend down everything within 5 years. Please don't do that, okay? There are ways that we can protect assets without giving them away or losing everything. People that have spent every dime and then call us, we tell them they don't need us at that point. They're going to get on these benefits. Where we can really work some magic is protecting this money while it's still there, okay? There's this other myth out there that Medicaid can take your home. Well, that's not really a myth. When you pass away after you've received Medicaid, the state of North Carolina does get to recoup what they've spent for you by taking your home, okay? But there's a special deed that any of the attorneys at our office can prepare for you to protect your home from nursing home costs. There is no 5-year look back. The day we do that deed is the day it's protected, okay? And as of today, this works in North Carolina. We do hundreds of these deeds a year. It's about $3,500, and your entire investment in your real estate is protected in an instant, okay? So if that is something interesting to you, please bring that up with the attorney when you talk with us. For people that don't want to necessarily protect their home now, we at least need to make sure that we have a really good power of attorney, because it gives us the ability to protect your home later. So for a lot of our clients, we don't need to do it now. Let's just wait and see. A lot of people are never going to go to a nursing home. A lot of people are. But as long as we have this power of attorney, that's the permission slip for us to protect your house down the road. And again, I'm beating a dead horse, but not all powers of attorney allow me to protect your house. Another myth, if we give assets away, we have to wait 60 months to qualify. It's just not true. It'll take 60 months before Medicaid no longer acknowledges it, but that doesn't mean we have to wait 60 months to apply. And before you start giving anything away, please talk to your attorney. Please. Medicaid is a very complex set of rules, and there are exceptions and loopholes and trusts that we can use. it's something to explore. I'm not going to spend too much more time today talking about this. It's a different type of trust that allows us to protect assets from the nursing home. And sometimes we don't even need a trust to do that. Okay, I've given you a lot of information today. Okay, well, you have a lot of knowledge, but unfortunately, that knowledge is not enough. We need an action plan. What do you need to do to get started with your plan? What do you need to do to make it happen? And been trying to make this easy for you. We've been posting a link throughout if you'd like to schedule an appointment with one of the attorneys. There's no time better than the present to get started. Okay. We don't need you to fill out anything and bring it to the office. That's been a big turnoff for a lot of people. So we try to make this easy. Let's just have a conversation, okay? When should you get started? Now, while you're healthy. I had a client who came to me at 100 years old and said, Blaire, I think it's finally time to get started. Oh my goodness. I'm so glad that they were still in a mindset or alive to be able to do that, but not the best time to wait, okay? There is no time like the present. You're healthy now. When you are mentally unhealthy or physically unhealthy, you're more subject to manipulation. We want to make these decisions while you're able to make it in the best mindset. So what is the investment to get this done right? So we're going to talk about fees, and I have a little the funny before the money. You get what you pay for, and we definitely want to avoid bargains when we're buying parachutes, when we're having brain surgery, when we're buying our fire extinguisher, and estate planning. We are not here to see when our estate plan does not work. So especially now with the outset of all of these internet wills, and I see you can now go to the big box stores and get it there. There's an app or a website where you can do it. We don't find out that these plans don't work. Our families are the ones that find that out. And we worked our whole life accruing your estate to now spend a couple $100, if you're trying to save money and just do it for a couple $100, like that's just a huge risk. So our trust plan currently is $6,850. This includes one deed to your North Carolina property. If you have multiple properties, we'll quote you that, but that first deed is included in that. And that includes the trust. That includes funding. So that includes putting all of your financial assets in the trust. So we contact every place where you bank, have investments, have retirement accounts, and we craft letters telling them exactly how your asset needs to be titled to that trust. And you may get forms back on the back end, and we have a person that will help you fill those out. We give you a customized owner's manual to explain how things work, where things are. It comes in a beautiful binder. Everyone with a trust will also get a will, okay? My hope with this will is it doesn't see the light of day because I've just told you wills are tickets to court. If we have to file a will, it is because something was not in your trust. So we are going to really work with you hand in hand to make sure that we don't have to use that unless it's absolutely necessary. Sometimes there's refunds or something that comes in at death that we just can't control, but absent that, I really don't want to have to use the will, but you'll still get one just in case. It's a safety net. You would all get our powers of attorney with that nursing home protection planning permissions, healthcare powers of attorney, advanced directives, living wills. If you have those documents from prior to 2008 or out of state, it's definitely time to get those updated. A HIPAA release. These are just some of the documents that are inclusive in the estate plan. Okay. If we have to do nursing home protection, that is an additional amount, okay? But a lot of our clients are okay for the time being, as long as you're healthy, with that power of attorney. That allows us to kick the ball down the road. It allows us to set up some of this planning later on, only if it's necessary. But for some people that really need that now, if we need to go ahead and create an irrevocable trust and put assets in it to start that 5-year protection, that cost is $9,975. But what I'm telling you today is a lot of you may not need that. All right. Even if I don't have that trust, I can still protect a large amount of assets. That, by the way, is for for estates under 5 million. They can go up after that. For those of you today that have listened to this and don't need a trust, a will package is still a great option. That's going to include the will, that special power of attorney, the healthcare power of attorney, and then all of those advanced directives like the living will, HIPAA authorization. You will get something called an estate planning letter where you can go through, and if you have certain knickknacks or jewelry or furniture, artwork that you want to give to people, you can handwrite that in over the years so that you're not having to constantly come back. And our will portfolio fee is $2,100 a person. So if you're married, that one's $4,200. And back to the trust for a moment. This trust portfolio fee is per family. So for this one, whether you're single or married, it's going to be $6,850. The will is per person though. So $2,100. We also piecemeal things. So maybe you just need that power of attorney. Everything else is good. That's usually about $500. So yeah, we can always piecemeal. So please don't be like this guy. Don't put your head in the sand. You now have the knowledge. Hopefully some of these complexities are not as complex in your mind. And really, the next step is getting started. So let's not procrastinate. No one is guaranteed tomorrow. Protect your family. So I'm going to hang around for a couple minutes. If you have questions, please put those into the live chat. I'm not going to be taking those on air. And again, we've been posting the link throughout if you'd like an appointment. If you prefer, let us know. We can call you tomorrow as well. Thank you so much for listening to me for this hour, and I hope you have a great evening. Bye.